I'll begin by asking, why are we here? Is it to relitigate a month-old election? Is it to change that election's results? It most certainly is not. It is to do what each and every one of us has sworn to do to the people of Wisconsin that we would, to protect and defend their most sacred right. My name is Dan O'Donnell. I'm a University of Wisconsin Law School graduate and a talk show host on WISN Radio and WIBA Radio. I am, however, also an investigative journalist. The nature of my work does mean that I'm an opinion journalist, but the essence of my work is investigation with one goal in mind: the truth. The disturbing truth that I have discovered over the past year of investigating is that here in Wisconsin, our right to vote has been perverted by fraud, allowed to run so rampant by the very people we trust to administer our elections, that the most vulnerable among us are having their most sacred right, the right to vote, stolen from them. Shortly after the November election, I was contacted by Susan, whose name I have changed to protect her anonymity, as she feared retribution for stepping forward. She's a disability service coordinator who works with severely developmentally disabled adults who live in various assisted living facilities in and around the city of Milwaukee. Every single one of her more than 20 clients told her that they were either pressured to vote for Democratic presidential candidate Joe Biden or had a vote cast for Biden in their name. Because of the ongoing COVID-19 pandemic, Susan's unable to visit her clients in their homes, so she has regular Zoom calls with them. In the days following the election, several of those clients all told her the same story. She relayed to me, quote, "I got curious after the first few told me what happened to them, so I asked every one of my clients, and every single one voted Biden. One gentleman told me, yeah, they just handed me a ballot that was already filled out." Another woman, whom Susan lovingly referred to as a born contrarian who likes the Chicago Bears because everyone else likes the Packers, said she wanted to vote for Trump primarily because every one of the staff members at her home likes Biden. Susan said, quote, "She told me I really wanted to vote for Trump, but a staff member at her home told me, no, he's a bad man. We're voting for Biden." And the staff member instructed her to vote for Biden, so she did, but she wasn't happy about it. None of us should be happy about this. These are severely cognitively and developmentally impaired people who rely on their caregivers for everything. But those caregivers have betrayed their trust. And this has happened over and over and over here in Wisconsin at assisted living facilities and nursing homes across the state. The law is so disregarded and the rules put in place are so lax that even the dead are now being allowed to vote. Ethel, whose name was also changed because her family fears retribution for coming forward, was one of them. She was 95 years old. She passed away in her nursing home in October after a long battle with dementia brought on by a stroke. Her daughter Janet contacted me after discovering that not only did Ethel vote absentee from that nursing home, but she's been voting absentee for years, even though she has not been mentally competent enough to since at least 2012. In fact, as her mental state deteriorated, her voting became more regular. How could this be? Janet has filed a police report with her local law enforcement agency, and under penalty of obstruction of justice, in a sworn statement says, quote, "Mom could sometimes not recognize me, remember what her last meal was, or even what day it was, yet she voted." And even though Janet died in October, even though it is illegal for a deceased person's vote to count in this state, Ethel's vote was counted. Janet immediately went to her mother's care facility. She told police from her sworn statement, quote, "I inquired who had requested a ballot for her and had access to her to assist in filling out the ballot, as I have not been able to visit her personally for months. They never gave me an answer on how she received a ballot." The answer lies, sadly, in the unconscionable manner in which the Wisconsin Elections Commission, the very board that this state trusts to fairly and impartially administer elections, ignored the clear letter of state law and made vote fraud like this less a possibility than an inevitability. Time and time again, using COVID-19 as an excuse this year, the WEC simply replaced the law with its own disastrous guidelines. Wisconsin Statute 6.875 governs absentee voting in nursing homes and assisted living facilities and expressly prohibits staff members from assisting residents in filling out their ballots. Under the statute, the local municipality must deputize 2 special voting deputies. The statute makes clear that these cannot be nursing home workers. However, the WEC determined in March that COVID-19 made it simply too dangerous to allow these special voting deputies in nursing homes. So they willfully violated state law and allowed nursing home staff members or anyone else who had access to the facility to help residents vote. These people are not trained, they are not observed, and they are legally not allowed to help people vote, but they did anyway because the WEC told them they could, and unsurprisingly, this power was abused. Janet told law enforcement in a sworn statement that she believes the facility's activities coordinator or social worker stole her mother's vote, since Ethel was so diminished mentally that she could not follow current events. In her sworn statement, she said, "I inquired how they made her choice without any knowledge of current events or news. He told me they asked residents who they had voted for in the past, and following party lines, that would be the choice. I asked, so if she could only recall JFK as president, Democrat would be the choice? He replied, yes. Asking him about my mother's impaired vision, how could she even be sure that whoever assisted would fill the ballot out to her choice? He said he hoped that those who assisted were honest." Ladies and gentlemen, does blind hope sound like acceptable oversight of election integrity to you? It wasn't for Miriam. She died on October 10th, and in the final 6 months of her life had mentally deteriorated to the point where she could no longer even speak English. She was born in Germany, and for the final months of her life could only speak German. Yet somehow she voted in both the August congressional primary and November's presidential election. If she could no longer understand English, how could she have filled out a ballot in English? She couldn't, but she did. Or rather, her family told me, someone else did for her. As one family member put it, quote, "This is fraud, pure and simple." Once again, even though Miriam died 3 weeks after casting her ballot, 3 weeks before Election Day, and even though under Wisconsin law, her vote could not be counted, it was counted. Ladies and gentlemen, for more than a month now, I've been investigating shockingly similar stories of vote fraud targeting the most vulnerable among us. A 102-year-old woman who suffered a stroke 6 years ago and doesn't recognize her own children, yet has been voting absentee by mail every single election. A 101-year-old man who's so far gone that his daughter told me, quote, "I want to know who's voting for him because there's no way he can vote on his own." A 95-year-old woman who could no longer form complete sentences, no longer even hold a pencil to fill out a ballot, but who somehow did fill out a ballot on October 12th while in hospice 2 days before she died. Yes, her vote, according to the myvote.wi.gov database, counted too. And so, ladies and gentlemen, were the votes of literally tens of thousands of people who committed election fraud by falsely claiming to be indefinitely confined. Wisconsin Statute 6.862 allows voters, like the ones I described, who are in nursing homes, who are unable to leave, who are, in truth, indefinitely confined. They can mark themselves as such for an indefinite period because of age, physical illness, or infirmity. Now, this allows them to have ballots automatically delivered to them without having to fill out separate request forms, and crucially, it allows them to bypass Wisconsin's voter ID law. Last year, 2019, the McIver Institute found there were a total of 72,000 indefinitely confined voters in this state. Right now, there are nearly 250,000. That's a 238% increase in less than a year. Of those new indefinitely confined voters, the Republican Party of Wisconsin determined that 31,000 in Milwaukee County and 15,000 in Dane County do not have a photo ID on file with their local clerk's office. That's an 854% increase in Milwaukee County and a 1,062% increase in Dane County. It also means that 46,000 voters in those two counties voted without having to show a photo ID ever, in direct violation of Wisconsin law. Now, why did such a massive number of voters suddenly decide in Wisconsin's two largest counties that they were indefinitely confined? Because the clerks of those counties violated state law and told them to. On March 25th, just days before Wisconsin's presidential primary, both Dane County Clerk Scott McDonald and Milwaukee County Clerk George Christensen issued guidance that because of the ongoing pandemic and Governor Evers' safer at home order, every single voter, regardless of whether they themselves were actually indefinitely confined, could claim that status because obviously we couldn't leave our homes. But we could. To go to stores, to go to hardware stores, department stores, even in Wisconsin, liquor stores. The advice was so patently absurd, patently unlawful, that the Wisconsin Supreme Court took the unusual step of stepping in to issue guidance that the guidance that they had issued was wrong and unlawful, saying, quote, "Voters may be misled to exercise their right to vote in ways that are inconsistent with Wisconsin law." The damage, though, is already done. Immediately after McDonald and Christensen issued this unlawful advice, the number of indefinitely confined voters ballooned from 72,000 to 200,000. An additional 49,000 voters claimed indefinite confinement ahead of the November election. Tens of thousands of them weren't actually indefinitely confined. In fact, just the numbers I have been able to find include voters who claimed indefinite confinement but attended jazz concerts, parties, weddings, went to work, even traveled out of state. One woman I investigated claimed indefinite confinement, yet has as her profile picture the phrase, quote, "I can't stay home, I'm a nurse." One woman claimed indefinite confinement, but posted pictures of her what seemed to be wonderful, well-attended wedding. Another posted a picture of herself and her boyfriend at Devil's Lake State Park. Another posted in early August about visiting Hobby Lobby and going to church with others. One man visited Vern's cabin in September. Another posted a picture of himself on a bike ride. A woman attended a party that same month. How do I know? I attended the same party. And I can tell you she was not and is not indefinitely confined. Each of these voters may have committed election fraud, which under Wisconsin statute 12.13 can involve making false statements to the municipal clerk, board of elections commissioners, or any other election official while on or under or not under oath. Now, since a declaration of indefinite confinement is a statement to a local election official or board that one's disabled if one is not, that is potentially a felony. That is, under the statute's, election fraud. Why were these clerks encouraging it? Why didn't the Wisconsin Elections Commission punish those clerks or rebuke them in any way? Why instead did the WEC spend more than a year doing everything it could to ignore the Wisconsin statutes and instead issue orders in direct opposition to them? The WEC was legally required to remove 200,000 old names from voter rolls, but it didn't, and even was held in contempt of court for failing to do so. The WEC ignored the clear letter and intent of state law in denying both Kanye West and the Green Party access to our state's ballot so that they would not take votes away from Joe Biden. The WEC looked the other way when the city of Madison held illegal ballot harvesting operations in 206 city parks and coordinated with the Biden campaign in promoting them. The WEC instructed municipal clerks across the state to ignore state law and illegally fill out mail-in witness addresses instead of returning the ballot envelopes to voters to correct as the law requires them. All of these decisions violated the clear letter and intent of state law, and obviously all were designed to influence the outcome of last month's election. Ladies and gentlemen, we are not here to change the results of that election or any election, but to challenge the systematic erosion of the rule of law. Without that, and without elections that exist within its framework, we have nothing. Not a state, not a country, and not even our most sacred individual right, the right to change our state, our country, and our lives with our vote. Here in Wisconsin, we take that right very seriously. We're the birthplace of both the Republican Party and the progressive movement. We are here now to ensure that the legacy of both is upheld and can endure. We're here because we care about the most vulnerable among us and won't sit idly by while their votes are stolen from them. We are here because we won't tolerate the rule of law to be ignored, subverted, and trampled on. We are here because this should concern all of us, Republicans, Democrats, Wisconsinites, Americans alike. We are here because these issues are far bigger than any one election, any one political party, or any one of us. And we are here because we know it. Thank you.